All right. Good morning, everyone. This is Judge McBurney. Sorry, we're getting a slightly late start. I misread the calendar and thought we were starting at 9:45. We should be at this point ready to discuss Shane Williams's case. So let me take some attendance here. We've got Mr. Rao, the prosecutor, here in court. So I've got the state side of things. Do we have Attorney Freeman on the call?
Good morning, Your Honor. Attorney Trip Freeman on behalf of Shane Williams. How you doing this morning?
I'm well. How are you, sir?
I'm doing well, Your Honor.
And your client?
My client is present.
Mr. Williams, I need to see you and hear you.
Yes, sir, I'm here.
There he is. Excellent. Okay. We've got Ms. Rivers, our court reporter. Ms. Rivers, you ready to go?
Yes, Judge, I'm ready.
Fantastic. And we've got Ms. Crawford from Department of Community Supervision. So we've got everyone we need. This is position 9 from our trial calendar that's set to start on Monday. State versus Shane Williams. It's indictment 19 SC 165436. And Mr. Freeman, my understanding is that Mr. Williams is prepared to enter a plea in the case. Is that correct?
Yes, Your Honor.
Is it a negotiated plea or non-negotiated?
It's a negotiated plea, Your Honor.
All right. Mr. Williams, I need to cover a couple things with you before you're put under oath. First, you have a right to be here in court, in open court in a public setting, but you can waive that right and proceed from wherever you are right now. Are you waiving your right to be here in open court?
Yes, sir.
You also have a right to have Mr. Freeman by your side so that you can consult with him should you have any questions or concerns about what we're working through. But you can waive that right as well. Do you waive your right to have Mr. Freeman sitting next to you during this conversation?
Yes, sir.
Importantly, Mr. Williams, I'll let you know that if you need to speak privately and in confidence with Mr. Freeman, we can easily make that happen. I can put you and Mr. Freeman in a breakout room where the two of you can see each other and hear each other, and we cannot. So should something come up where you want to talk to him in private, let me know, wave your hands, interrupt, do whatever you need to do, and I'll move the two of you into one of these breakout rooms where you can take the time you need to talk about what you need to talk about. Do you understand?
Yes, sir.
Great. Then if you are ready to go, Mr. Rao.
Yes, Judge.
You're up.
And for the record, I believe 3 members of the victim's friends and family are present, and I believe that there are three impact statements that would like to be read.
Great. We will work through all those, and I should make clear, obviously, anyone and everyone from the victim's family is welcome. This is also being live streamed on YouTube, so if people are not able to get into the call but want to watch what's going on, people on this call can let family members or friends know that there's a YouTube feed of what's happening. All right. So at the appropriate time, I'll ask you, Mr. Rao, either to share those victim impact statements or to call upon the family members to share what they want to share.
Yes, Judge. Mr. Williams, would you mind raising your right hand, please? Do you swear or affirm that the statements that you provide the court today will be true and correct?
Yes.
Okay. Please state your true, correct, and legal name.
Shane Lamar Williams.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
34 years old, 12th grade.
And are you able to read, write, and understand the English language?
Yes.
And Judge, for the record, the state will be null processing counts 3 and 4 off the indictment. Based on the resolution proposed, count 2 would merge into count 1 as a lesser included. Count 1, homicide by vehicle in the first degree, Mr. Williams carries a minimum 3 years to a maximum 15 years in confinement. And between the state and the defense, a proposed resolution has come forth, and the state is recommending a sentence of 7 years on probation on the charge of homicide by vehicle in the first degree. Do you understand that, Mr. Williams?
Yes.
Okay. And have you discussed the charge with your attorney as well as the sentence that you will be receiving, and have they advised you of the potential minimum and maximum sentence with respect to the charge?
Yes.
You understand that you have the right to plead either guilty or not guilty to this charge, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses that you might have should this case go to trial?
Yes.
Do you need more time to discuss this case with your attorney?
No.
And are you satisfied with Mr. Freeman's services?
Yes.
Mr. Freeman, do you waive formal reading of the indictment, sir?
Yes, I do.
And do you waive any and all defects therein?
Yes.
Okay. And as stated before, Mr. Williams, the negotiated plea of guilty is on the charge of homicide by vehicle in the first degree. And the state's recommendation to the court would be 7 years on probation. Do you understand, sir?
Yes.
Okay. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
That's a question for you, Mr. Williams.
Yes.
Okay. Mr. Williams, do you understand that if you're currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes.
And do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you're not a U.S. citizen, a guilty plea conviction will affect your immigration status and will result in deportation, regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
And do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you'll be guilty of a felony which carries a sentence of 1 to 5 years in prison?
Yes.
And are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes.
Mr. Williams, have you ever pled guilty to or nolo contendere to, or have ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No.
Has your attorney explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in the indictment?
Yes.
Do you understand that you waive any and all defenses by entering a plea of guilty today?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after trial.
Yes.
Has anyone forced, threatened, or promised you anything for you to enter a guilty plea today?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
And how do you plead to the charge of homicide by vehicle in the first degree in this indictment?
Guilty.
Is this plea freely and voluntarily given with the full knowledge of the charge against you?
Yes.
And do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
Yes.
Your Honor, if this case were to go to trial, the state would expect the evidence to show that on March 14th, 2017, at approximately 8:36 a.m., at 6295 Oakley Road in Union City, Georgia, within the jurisdiction of Fulton County. The defendant was operating his motor vehicle in the morning and was driving approximately 27 miles per hour in a 35 mile per hour speed zone.
Under the speed
Under
limit.
the speed limit, Judge, and that was assessed by the Georgia State Patrol in their observation of the surveillance video in this case. Surveillance video did not capture the actual crash, but did capture the vehicle exiting the camera approximately 350 feet from the point of impact. So they were able to determine the speed as well as the point of impact, which was consistent with the defendant either driving under the speed limit or at the speed limit. The defendant crashed into the victim, Delvin Brown, who was operating a wheelchair on the roadway. Mr. Williams did not flee the scene, and it was reported in the incident report that he did in fact also call 911. When Union City Police arrived at the scene, they took a statement from Mr. Williams, and to the effect as it relates to the context of what happened, Mr. Williams said that he was distracted while operating his vehicle. There wasn't much description beyond that other than he was distracted. And by the time he realized that Mr. Brown was operating his wheelchair in the roadway, it was too late. And despite his best attempts to brake, did collide with Mr. Brown, resulting in him being thrown off his wheelchair and eventually succumbing to his wounds.
Is the wheelchair a motorized wheelchair, or
Yes,
Mr.
Judge.
Brown was propelling himself?
It was a motorized wheelchair, and I think that that's indicated as well in the photographs that were taken of the scene.
Okay.
And it apparently, Mr. Brown, it is assumed that he used the roadway to operate his motor vehicle or operate his wheelchair because there was no sidewalk in the area at the time. Officers responded, and once this case was presented to the DA's office, we indicted the defendant for the following charges. In looking at his criminal history, the defendant has no prior felony convictions. The defendant does have 3 prior driving tickets, one from 2014, one from 2015, and one from 2016. The first 2 are for speeding, for going, I think, 88 and a 70. And the second one was going 60 and a 45.
And I would object because we won the 404B, which would prohibit his driving record from coming in.
Well, it doesn't come in as evidence at trial. I'm certainly entitled to hear about it in the same way you may tell me things about Mr. Williams that you think support leniency. But I was aware of these anyway because I read Judge Reeder's order that excluded them from trial. So the cat was already out of the bag. Keep going, Mr. Rao.
Yes, Judge. And the last conviction that he has was from a 2016 offense state for failure to yield right of way. That was in Fulton County. And that is the only history that Mr. Williams has. And it appears that based on the fact that he was not speeding, at least that was assessed by the Georgia State Patrol, those are the only traffic offenses that he has, even though they're not necessarily relevant to the facts of this case.
Okay. Thank you. You mentioned that there were some victim impact statements, family statements. Tell me how that's going to work. Are you reading something? I know we've got a few folks who've joined the call.
Yes, Judge. I believe each of them would like to read it to the court. And I think we can start with Miss Brown, Octavia Brown, who I think also would like to show you a picture of the deceased.
Ms. Brown, whenever you're ready, I'd like to hear from you, please.
Yes, to unmute.
She's on mute. Miss Brown, you're on mute. We can't hear you.
Okay, I'm so sorry.
You're fine.
That's okay.
This is
All
a
right,
picture of my husband, Delvin Brown, along with the wheelchair that he was in, as well as the dog that he was walking, our dog King, that morning of his death. I also have another picture of my husband who played music, loved music, and this is a picture of him and his guitar that one of the witnesses gave to him, who was teaching him how to play the guitar. Okay. My impact statement. 37 years of marriage is a long time, so I was so unprepared for Delvin's death. I loved him so much and missed him tremendously. If Mr. Williams would have met Delvin, he would have been fast friends because Delvin never met a stranger. He loved people and would talk to anyone and befriend anyone. He was truly a people person. Delvin was a mechanic by trade, but he could fix anything. He was good with his hands. If he had ever seen Mr. Williams stranded or having an automobile problem, he would have stopped immediately and tried to help him. Delvin would never pass a person in need of help and not stop. He truly loved people. In 1996, because we wanted to give back to our community, Delvin and I started a nonprofit organization he called The Rare View and helped the community we did. We helped ex-offenders find employment, housing, and/or training, furniture, and clothing. We purchased a 12-station mobile computer lab that Delvin drove around Metro Atlanta, offering tutoring, mentoring, and homework assistance to juveniles and grades pre-K through 12. While Delvin was alive, we donated countless computers and toys to needy families. Delvin's biggest achievement before his death was his spiritual growth. He loved Jehovah and would talk to anyone he met about God. I know he's in Jehovah's memory and has the hope of the resurrection. I know unforeseen occurrences can befall us all. However, what really saddened me about Delvin's death is Shane Williams' lack of empathy for me and my family. Even though you have shown no empathy for me and my family, Shane, I have empathy for you. I forgive you. It has to be a heavy burden and a heavy weight on your heart, knowing that you were the cause of Delvin losing his life, even unintentionally. It has been 1,595 days since Delvin walked out of that apartment on April 14th, 2017. Yet it seems you do not want to spend even one day away from your family because of it. I understand. However, I hope you at least have a deep appreciation now for the value of life. I also hope you and your family will watch a YouTube video, The Life and Legacy of Delvin Anthony Brown, #1, about Delvin's faith, his family life, his friends, and contributions to his community. Delvin is asleep in death now, and I know he would want you to learn what that means, just as I do. And you are welcome, Shane, to contact me if you would like to know more about what it means to be asleep in death. Thank you.
Ms. Brown, thank you so much. I appreciate you providing that insight into the life of your husband. It sounds like he was an amazing person, and we're obviously all very, very sorry for your loss and the larger loss of the family. But I appreciate you helping paint that picture of who Mr. Brown was. Mr. Rao?
Yes, Judge. I believe Gerald Brown would also like to read an impact statement to the court.
All right, Mr. Brown?
It's going to be read for him. The victim's advocate is supposed to read it for him.
She's right here. She's standing here in the courtroom. And so If you don't mind going to a microphone, defense table or podium, that would be fantastic.
Good morning, Judge.
Good morning.
Dear Judge McBurney, my name is Gerald Brown, brother of the victim Devin Brown. Let me start by saying that I think this case was tainted from the start. The officer on the scene did not give the defendant a toxicology test. He determined on his own that the defendant was not impaired. Well, that's something we'll never know now. But what we do know is my brother Devin Brown isn't here because of the defendant. The defendant, Shane Williams, didn't even talk to the family to express his remorse. What kind of person takes the life of another and doesn't express his remorse to the family? I'm beside myself because of his actions. Shane Williams gets to go home every day to his family. Now I ask, where is the justice in that? He's not even doing any jail time, just getting probation. I will never be satisfied with the justice that this defendant is receiving. Where can you kill a man and go home every day? The system is unjust. I hope and pray that the defendant gets what's coming to him one day. Sincerely, Gerald Brown. Thank you.
Thank you. And thank you, Mr. Brown, for sharing that perspective. You mentioned there were 3 people, Mr. Rao.
Yes, Judge. Sir. I believe Ms. Clemens as well.
Ms. Clemens, good morning.
Good morning. Let me unmute.
No, you're good. You're unmuted. Keep going.
Oh, am I? Oh, thank you. Good morning. My name is Sarah Clemens, and I've had the great pleasure of knowing Delvin and Octavia Brown for many years now, through our mutual sons when they were in high school. Now both boys are grown, naturally, and productive citizens. We are very close and dear friends and with much shared history. I have many regrets in regards to the death of my dear friend Delvin. I'm sorry. I will attempt to share just a few. I regret not having my friend in my life to share the pleasures that we enjoyed together in making music. He, a brilliant and talented keyboardist, and me, the guitarist. I really miss his childlike joy of learning to play the guitar as well. He was always eager and excited and prepared for every new lesson we had. Sort of a kindred spirit, he and I. Music, to me, is often the beat of the heart, and we shared that beat. His enthusiasm inspired me, and I miss that. I miss his passionate, really passionate dedication to his family and his strong advocate in partnership with his wife, as the two of them formed an organization to help those people less fortunate. They even provided assistance in housing and training and employment opportunities for ex-offenders. They established a mobile computer lab for underprivileged kids. And each year they provided tons of gifts and toys for children. I miss that. I regret that Delvin has never known his granddaughter and his great-granddaughter now, and for them to have never known a truly loving grandfather. I miss seeing the love he had for his beloved dog, King, who was with him on that fatal day. I miss so many things about Delvin Brown, but mostly I miss watching him mature spiritually, as Mrs. Brown indicated, in his journey of making those necessary changes in life to please the Most High and become his friend. This journey that gave Delvin so much joy, and he shared that joy and the reason for it with everybody that would listen to him everywhere. I miss that. No amount of regrets will change the past. Excuse me, but my hope has been and still is that Mr. Williams would have reached out to Delvin's wife of 37 years to offer some semblance of sorrow, regret, some semblance of care and concern, some semblance of compassion. I regret that. Thank you, sir.
Thank you, Ms. Clemens. Appreciate you adding further context to the portrait of Mr. Brown that his wife helped develop and that his brother shared. I can see your guitar in the background. Apparently you don't get far from your guitar. But I appreciate you taking the time and putting together those thoughtful words. Mr. Rao, anyone else? I noticed there are a few other Browns on the call. I don't want to preclude anyone from commenting if there was anyone else who wanted to speak.
I was only made aware of 3 victim impact statements, Judge. So I believe if that's the case, I'll
Okay.
confirm with the family.
There's a Tanisha Brown on the call, and no one's trying to silence you, ma'am, if there was something you wanted to add, if you're on for this plea. No? Okay. Ms. Crawford, Mr. Rao has represented that Mr. Williams has no felony history here in Georgia. Do your records confirm that?
That's right, Judge. He has no criminal history here in Georgia.
Okay, thank you.
You're welcome.
Mr. Freeman.
I'm muted. Good morning, Your Honor.
Good morning. Tell me what you want to tell me about Mr. Williams, if there's anything you want to add.
Yes, Your Honor. Mr. Williams, I would like to begin by expressing condolences to the family of Mr. Brown and to everyone present on the call who is here on his behalf. My client, Mr. Williams, is greatly remorseful for what happened. It was an accident. It was not his intention. I know the charge here is first degree, but he was not, his actions were not intentional at the time. When Mr. Williams retained me, I spoke with him and I asked him, had he spoken to the family? And at the time he told me he had not, honestly, because he was just scared and he just felt so bad. He did not really know how to approach it. I feel like after listening to the statements, hopefully moving forward, he will reach out to the family, but he has repeatedly expressed a great deal of remorse to me. This is something that, 2 lives have definitely been impacted permanently as a result of this. Mr. Brown's family will not be the same moving forward. Also, Mr. Williams will never be the same moving forward as well. I know this has greatly affected just his mental state in terms of just, his level of sympathy for what happened. At the time, as Mr. Rao has expressed, Mr. Williams was actually following the rules of the road. He was not intoxicated. He was not speeding. He was in his lane of traffic, moving with the flow of traffic at the time. Unfortunately, it was an inherently dangerous setup, which I think is the biggest factor for the accident overall. The initial prosecutor who was assigned to this case was Adrian Love. And Adrian Love and I met at the scene of the accident. I went out there with her and one of the state's investigators. And at this time, the accident scene had not been changed at all. And there was an apartment complex that's about maybe a half a mile or a quarter of a mile from a gas station store. And there was no sidewalks at all. So everyone, even when we were on the scene just investigating the accident scene, we saw approximately 50 people walking from the apartment to the store. It was basically a major thoroughfare where there had been a kind of a path walked in the grass. There was a dirt path because people walked back and forth in that area so much. However, later on, when I went out to the accident scene myself, just to do further investigation, Union City and/or Fulton County has made a number of changes there now. They've added sidewalks, they've added a lot more safety features. So moving forward, hopefully this will never repeat. Mr. Brown, as it's mentioned, was in an was on a motorized wheelchair. So I don't know if that possibly prohibited him from being able to ride on the dirt, how some of the pedestrians were on the dirt. And therefore he probably had to ride his chair on the roadway so that he would be able to get to the store. But since then, Union City and/or Fulton County has made a number of safety changes there. They've added sidewalks, they've added crosswalks, and a lot of other safety things to prevent something like this. Mr. Williams is a father of 3. He's married. He's been employed by Americold Warehouse for 8 years. He works in their warehouse as one of the, I want to say one of the facility people in the warehouse. At the time, he was headed home from work when this accident occurred. He was not, he did not have any intention of injuring anyone. He's not someone that's involved in criminality. He has no felony history and has no history of anything like this on his record. I do think it's in his best interest that he take the plea at this time. We would ask that he be allowed to plea under Alford v. North Carolina. And the prosecutor has mentioned first offender. We would also ask that he be allowed to plea under first offender. I do understand that the term of the probation is 7 years. I would ask the court if it's possible if Mr. Williams could have some type of provisional license which would allow him just to drive to work, and that's it. Or if there's anything that would allow him just an ability to be able to drive to work. Otherwise, that's the only thing I would say at this time. Again, I would like to express great condolence to the family of Mr. Brown. I personally will check out the YouTube on Mr. Delvin Brown because he sounds like he was an incredible individual and a very talented musician. I actually play music myself, so I would just like to see, and learn more about him. And I would like to thank his family for being present. I understand, the anger and frustration that's been expressed by some people. I also understand the remorse, and I would like to apologize to Miss Brown because, again, Shane Williams has talked to me several times about just how remorseful he is. I think he's just been afraid to approach you. He doesn't know what to say, which is why he has not said anything. But at the time, Mr. Williams did attempt to offer assistance. This was not at all his intention. He did call 911. He also stopped and got out and tried to, offer assistance while they waited on the first responders. But I think this is just something that, unfortunately, the way that area on the roadway was designed over there, they just did not have the proper things in place in terms of sidewalks and a way for people to be able to traverse safely back and forth from the apartment complex to the store, and especially anybody that was handicapped or special needs. There were really nothing in place there for him to have been able to go back and forth. But that's all that I would say at this time, Your Honor. And I feel like Mr. Williams would also like to speak briefly just to express his condolences and remorse.
We'll get to him in a minute. You have said, first of all, thank you for your comments and for explaining a little bit to those of us here as to why Mr. Williams may not have immediately reached out to the family, and I'll touch on that in a minute as well. But you mentioned an offered plea, and that confuses me because it doesn't sound like the facts of the situation are in any way contested. So you need to help me understand why you think that an offered plea would be appropriate. The first offender, I'll have the dialogue with Mr. Williams. I think he qualifies for that. I think this is an appropriate scenario if that statute qualifies for first offender. And I'll look at that in a minute. But walk me through Alford. I'm not following that.
Yes, Your Honor. And just brief in terms of Alford, if you're not comfortable with it, I'm fine with that. But the reason I did ask for Alford plea was that based on the charge itself, first degree, kind of infers that there was some type of intention, and also that Mr. Williams has a lot of facts in his favor that if we go to trial, we felt like things, possibly could go his way. However, overall, it is in his best interest, or we feel, and he feels it's in his best interest at this time to take the plea. That was the only reason I mentioned Alfred, but if the court is not okay with that, then I'm fine with just.
I'm
Alfred.
Yeah, I'm not inclined to do that. The elements of first degree vehicular homicide are causing the death of another, in this case, Mr. Brown, effectively unintentionally. It's without malice aforethought. So that was, nothing is alleging in the indictment that Mr. Williams intended the outcome of the events, but that it was his reckless driving, in other words, being distracted and not noticing what sounds like would have been a pretty noticeable object ahead of him, a guy in a wheelchair walking a dog. That's the reckless driving piece. So those seem to me to be the essential facts, and they don't seem to be contested. But it sounds like that's not a deal breaker for you, Mr. Freeman, but I'm not inclined to do an offered plea.
I understand, Your Honor, and we can move forward there.
Okay.
In terms of provisional license, is that something the court is able to do at all, just for a license that will allow him just to go to work?
The answer is I'm not sure. I'm not saying no to that. It is something that we often explore when we're working with people in our accountability courts who have had their license suspended because of an arrest and there were drugs in the car, but it was not an impaired driver. And we try to get folks to be able to drive to work and to the treatment center, because otherwise it becomes a pretty serious imposition. So I don't know the mechanics of that. I also don't know if, given these charges, that's something that would even work for Mr. Williams. So I'm not saying no. I'm saying that you should explore it on his behalf. And if in fact DMV would support something like that, there's a form that I need to fill out, which I'd be happy to do, but I'm going to put that assignment on your plate, Mr. Freeman, rather than Mr. Rouse, to see if after it's entered a first offender plea, et cetera, that's something that DMV actually would authorize if a judge signed it, if that makes sense.
Yes, that does make sense. That's actually what I advised Mr. Williams. I told him there's a good chance that the court may say that that's something that we need to reach out to DDS regarding.
Okay. Let me turn to you, Mr. Williams. I've got a couple questions for you, and then you have an absolute right to allocute. That's the term they use, and that would be to share with me anything you want to share about this situation, how you're feeling about it, et cetera, as I know you've been waiting for a while to be heard on this. You have 3 kids. How old are your 3 kids?
I have 2 boys. One is 15, the other's 14. I have a daughter that is 7 years old.
Okay, they're all in school?
Yes.
Okay, and do you live in Union City or work was in Union City?
I stay in Riverdale now. I work in Atlanta off of Fulton Industrial Boulevard. And sometimes I take the back roads to avoid the highways to come home.
Okay, so that's why you were on the road you were on in March of 2017, was back roads from work to home?
Yes.
Okay, got it. Tell me, Mr. Williams, what you want to share about this situation.
I really just want to speak to the family and the friends of Mr. Brown. First, I want to say that I'm deeply sorry. I really am. And I know I didn't reach out, and it's because that I didn't know how to approach you. I didn't know what to say, and I was scared. I did reach out to, I believe to be his nephew at one point, Alexander. And we spoke a few times, and I was telling him how scared I was, and he told me how you were feeling, and I was supposed to be in contact with Ms. Brown, but I was so scared that I never brought myself to do it. Hearing you speak about Mr. Brown, hearing all you speak about Mr. Brown, it sounds like he was a great man. And I have a family of my own. I can never imagine something happening to them where they were just out of my life and gone forever. I couldn't imagine it. So I can't imagine what you're going through. And I do want to talk to you in person and reach out to you so we can talk more about it and I can get to know you more as a person and you can give me more insight about Mr. Brown. And I'll also check out his YouTube video and anything else I need to so I can get to know the person that I intentionally took away from you. I'm sorry.
Thank you, Mr. Williams, for sharing that. And let me share with the Brown family that what you experienced, by which I mean the alleged perpetrator not reaching out to you to express remorse or sympathy or condolences, that's fairly typical. Until Mr. Williams's case was resolved, he was at legal risk. In talking with you all, he might say something in a way that you misconstrued, and his statements to you could be used against him in court. So he could have said, I'm really sorry. I don't know what he could have said, but it could have been something that then you share with the district attorney's office, and all of a sudden they're using Mr. Williams's effort to say he's sorry against him in court because he talked about the way in which he was driving or something like that. And so it's common that the kind of apology that you just heard from Mr. Williams, which struck me as very sincere, waits until now. That is not a sign that Mr. Williams didn't care. It's a sign that his lawyer was doing a good job in saying you can't interact with these folks yet because they could testify, you might testify, and it's just too risky to bring something up. And that may seem kind of a cold-hearted calculation, Ms. Brown, Mr. Brown, and Ms. Clemens, but it's the reality when you're charged with something as serious as vehicular homicide. The stakes are real high because the loss was so significant. There's not a happy ending to this story. The loss is permanent. We can't bring Mr. Brown back. His memories are rich, though, and it sounds like he touched many lives. As someone who, on an almost daily basis, is dealing with people who have struggled with being incarcerated and trying to rebound, it is heartening to hear that Octavia Brown, you and your husband dedicated a lot of your time and energy and money to trying to lift those people up. We deal with people in the criminal justice system all the time. And I think Mr. Williams is an example of that, who've made a mistake. They are not here because they are evil people. Those folks are out there, but they're few and far between, fortunately. It's usually folks who are down on their luck. They're suffering from a mental health challenge or an addiction, or it is a tragic accident, which is how I'm understanding the facts in this case. And I understand Gerald Brown's perspective. He thinks there should have been more police work, but from everything I've heard and read in the case file in this case, the police did their job. And the only evidence was that Mr. Williams wasn't paying as much attention as he should have, and it had a tragic result. I think it was helpful for Mr. Freeman to paint the picture that there was a reason why Mr. Brown was out in the street. He wasn't operating his wheelchair recklessly. There's no sidewalk at that time that he could be on. And so there was this tragic confluence of events where Mr. Williams didn't have his eyes where they should be. Mr. Brown is forced to be out in the street because there's not adequate sidewalk, and tragedy ensued. I don't share that with you to say now everyone should feel better. You are going to heal in the way you heal. I hope that Octavia Brown, you will take Mr. Williams up on his offer, and Sarah Clemens, you'll do the same if you find it in your hearts to spend time with Mr. Williams to help him better appreciate what an amazing man Mr. Brown was. I hear in Mr. Williams someone who wants to learn more about the life that was lost. He obviously is forever connected to Mr. Brown in a real sad way. And so maybe something good can flow out of that. But I think that the parties have reached a reasonable resolution. Again, I feel Gerald Brown's pain, but I don't know what is gained in this society if Mr. Williams goes to prison for a couple of years because of what happened. It does not bring Delvin Brown back. It does not leave a father in place for Mr. Williams's 3 kids. And I don't think we advance much. There are crimes where punishment is appropriate and the punishment should be extremely severe. But this situation, which seems again more to be a tragic accident, isn't one of those situations. Mr. Williams, I find there's a factual basis for your plea. I also find that your plea is knowing and voluntary. Voluntary means no one is forcing you to enter this guilty plea, but you're doing it because you believe it's the right way forward for you. Is that correct?
Correct, sir.
And a knowing plea is simply one that's entered into by a defendant who understands everything that's been discussed. Do you have any questions about anything we've talked about so far?
No, sir.
All right. Then I'm going to accept your plea. I'm sentencing you pursuant to the Probation Options Management Act. And what that means, Mr. Williams, is that while you are on probation, if you have a technical violation, that's something small, you miss a meeting or something like that, you'll deal with probation to handle that. You don't have to come back in front of me. But I'll tell you that if you pick up anything more serious than that, you're arrested for anything, that comes back to me and we will work through what the consequences should be. I'm inclined to sentence you as a first offender, but we need to talk briefly about that. The benefit of first offender, Mr. Williams, is that you will continue to have no felony conviction, which helps with employment. It helps if you want to go back to school, but you don't have to check that box that's on employment applications. You will be able to serve your probation, but if you successfully complete that, you'll continue to have no felony criminal history. That's the benefit. The risk, Mr. Williams, is that if while you were on first offender probation, which you will be for 7 years, you catch new charges and they are sufficiently serious, and certainly anything serious involving you and driving and someone else getting hurt would fall in that category. I can, and likely would, without a trial, resentence you as a felon up to the maximum, which in this case would be up to 15 years in custody. So you could, and I'm making this up, but if 3 years from now, there's another accident and someone's injured and the results of the investigation is that you were driving recklessly and felony charges are brought against you, not only would you have those new charges, but I could dip back into this case and say, clearly you did not learn your lesson. And I'm going to sentence you as a felon in this case, the Delvin Brown case, for up to 15 years in custody. So the risk is significant, but it's manageable. If you know that you will be able to, like you did for the previous 34 years, stay out of felony trouble, then it's a pretty sound proposition. Do you feel, Mr. Williams, like you understand the risks and the benefits of first offender?
Yes, sir, I do.
Do you want to be sentenced as a first offender?
Yes.
All right, I will do that. Mr. Williams, your sentence on count 1 will be 7 years. Those years will be probated. Count 2 merges into count 1, so there's no sentence on that. And the state is dismissing counts 3 and 4 and focusing understandably on the most serious count in the indictment, which is count 1. Your lawyer, Mr. Freeman, has already asked about getting a provisional license or a permit that would allow you to drive to work and home only. I'm open to that concept for the reasons I've already described. I just don't know the contours of how that might work, if it could work. This is a pretty serious charge, and it may be that you're not eligible for it. But I've asked Mr. Freeman to look into it. He can talk with the folks at DMV, and if it is doable, then I will help make that happen. I'm not opposed to it if it's possible. Mr. Freeman, we are proceeding off of a copy of your client's indictment because we don't have everyone in here to sign it. So I want to make sure you waive any issue that would arise from proceeding off of a copy of the indictment.
I do waive those, Your
Honor. Mr. Williams, I'm going to add one element to your probation, and that is that you will need to complete 100 hours of community service. You don't need to complete those tomorrow or next week or next month, but you'll need to do so in the first year or so of your probation. if you're doing well on probation and you've satisfied that condition, it's entirely likely that the Department of Community Supervision will petition me to cause your probation to become non-reporting. If you're doing well, they need to focus on the folks who aren't doing well and are getting in trouble again. So there's that opportunity out there for you. I'm not going to assign the nature of the community service, but I encourage you to work with your probation officer to see if there are opportunities in which you can give back to the community in talking about the perils of unsafe driving. I know sometimes a defendant and his lawyer will come already with a program in mind that my client's going to be talking at Mothers Against Drunk Driving meetings or something like that. Now, that's not you. I'm not suggesting that you were impaired in any way in your driving, but it may be helpful for you as you're working through the loss you caused if the way you're giving back during the community service is along those lines, where you're either working with victims of motor vehicle accidents or folks who were on the perpetrator side of that. That's not a requirement. The requirement is that you knock out the 100 hours of community service. It is also not a requirement, but an encouragement for me, and I've said this before, but I'm going to end with it, that you do follow up on what you said, which is to reach out to Ms. Brown and her family. And Mr. Freeman can get you their contact information if you don't already have it, or if you can't get it through, I think you said you had been in touch with Mr. Brown's nephew or a relative like that. But that's more for peace of mind and closure for you. I'm not going to make that a requirement because I wouldn't want to impose it on Ms. Brown if she's not interested in doing that. I just think that might be healthy for everyone involved. Mr. Williams, if you were here in court, you would be signing your indictment indicating you're pleading guilty, but you are appearing remotely. Do you authorize me, Mr. Williams, to sign the indictment on your behalf?
Yes, sir.
Mr. Freeman, may I sign it for you?
Yes, Your Honor.
And Mr. Rao?
Yes, sir.
Mr. Rao, anything else for the state in the Williams matter?
Not on behalf of the state, Judge.
Mr. Freeman, anything else on behalf of your client?
Just briefly, Your Honor, how does Mr. Williams go about getting in touch with probation initially for that first appointment, or just to make sure that he, meets with his officer and they get him started?
So you're very thorough. I'm about to be done, but Ms. Crawford, who you see on the screen there, is about to start. She is with probation. She will not be Mr. Williams's officer, but she is about to share with Mr. Williams and Mr. Freeman what Mr. Williams needs to do. Mr. Williams, Ms. Crawford's going to give you a date and a time to show up at probation. I strongly encourage you to make that meeting, because if you don't, the first thing probation is going to do in connection with your case is take out a warrant because you missed that meeting. So if you have to skip work that day, skip work, because that's when you're going to meet your officer and get the process going. All right, Ms. Crawford, if you would, please.
Good morning, Mr. Williams. I'm Ms. Crawford from probation. I need to get some information from you. I heard that you say you live in Riverdale. I think that's Clayton County. Is that correct?
Correct. Okay,
can I have your address, please?
1525 Judson, is Judson Way. It's Riverdale, Georgia, 30296.
Okay, I'm going to give you the reporting instructions. The address that you need to report to is 1331 Citizens Parkway. That's in Morrow, Georgia. 1331 Citizens Parkway, Morrow, Georgia, 30260. Your report day will be September the 14th. That's on a Tuesday at 10 a.m. I can give you my telephone number to contact me if you have any questions. It's 470-303-6860. And then I'll need to get an emergency contact person's name and telephone number and your telephone number to get in contact with you.
My telephone number is 919-327-0329.
What was the first three digits? I'm sorry.
919.
919, okay.
And the emergency contact will be my wife, Tasha Williams. And the phone number is 919-438-5392.
Okay, that's all for me. Do you have the date and the time and the address written down?
Yep, so it says 1331 Citizens Parkway in Monroe, Georgia,
That's correct.
And-
September 14th.
10 a.m.
That's correct.
And what was the zip code again? Sorry.
It's 30260. Do you have any further questions for me?
No, ma'am.
Okay, that's it. Thank you.
All right. Thank you, everyone, for joining in this call.
Thank you, Your Honor. May we be dismissed?
Yes, sir.
Thank you. Have a good one. And Mr. Rao, we appreciate you.
Thank you.
Thank you. And thank you again for sharing everything about Mr. Brown.
Okay, thank you. You're welcome.
Mr. Rao, you may want to get out of here while you can so you don't get attached to the next case. Yes, sir. Ms. Condrey, how did the Carnicero trial end? That was a marathon.
Yeah.
Did you think it would take that long?
For it because they were out for 40 minutes only and they were like, goodbye.
Okay.
So, but yeah, it was a good outcome.
Did you expect it to be that long?
The trial,
Yeah.
maybe just shy of that. I mean, it was a 30 witness
Okay.
case. But we had, I don't know if you've talked to her, but the courtroom setup was,
Yes, I got almost daily updates. We were trying to help.
so that was a good chunk of it,
yeah.
honestly. But
That needs to not happen again because it's
the fifth floor courtrooms are just,
small.
yeah.
Yep,
So we worked through it.
yep. It helped us test out things like a remote listening area, things like that. So. Just exactly. Ms. Young, is she meeting with her client right now, or did she step outside? Please.
Sorry, Judge.
No problem. You didn't know when we were going to end?
I was looking at the monitor and I saw who was at counsel's chamber and I said, oh, they're waiting for me. Sorry about that.
So, Ms. Young, we'll get your client out here in just a second. I wanted to just get an update from you as to where you think we're heading. You and Ms. Convery have done a great job of keeping Ms. Nelson updated, and we were maybe pleading, not pleading, maybe pleading, not pleading. Mr. Hinton needed to speak with his mother. Mr. Hinton suddenly had come up with an alibi witness 6 years later. We'll bring Mr. Hinton out in a minute, but what do you forecast happening today?
Thank you, Your Honor. His father and two other family members are here, so that's why I was outside speaking with them. I've spoken with his father yesterday and previously. I spoke with his mother yesterday. And what she has informed me is what I put in the motion, that she would like to speak with him, that because of the complications she has from COVID, she's not able to travel. She texted me this morning when I was driving in that she was unable to speak with him since she and I spoke yesterday about the specifics of the plea.
Okay.
I wanted to speak to Mr. Hinton. I've spoken with him twice this week for over an hour at the jail each time to make sure that we communicated about what the plea offer was, any questions he had about it, his rights should he decide to accept it, which as of Tuesday, he had said yes. When I spoke with him yesterday, he said no. He understands that he may be questioned by the court as to if he understands what the plea offer is. I've asked counsel if they would consider, if the court does roll the case over to September, to allow me to look into the things that he mentioned yesterday, as well as let his mother speak with him, as well as look into the appellate issues that I put in my first motion. His father mentioned bringing in other counsel, so they may decide to do that as well, in which case I would promptly inform the court and of course, counsel as well.
Okay.
So I would ask them if they would consider holding it over to the next calendar call, which I believe is September 23rd, if the court was inclined to allow the continuance.
Okay, got it. Thank you for that update. Let's bring Mr. Hinton out, please. Good morning, Mr. Hinton.
Good morning.
How are you?
Doing good.
Good. Mr. Hinton, you were brought over today because your lawyer, Ms. Young, and the prosecutor had indicated there was the possibility that this case was going to resolve by way of a plea rather than trial. Ms. Young gave me a more recent update electronically, meaning she sent an email to some people that went to me, and then just a moment ago that now maybe it's not going to be a plea. Ultimately, of course, that's your decision, but we need to talk about a few things on the record today so that I'm comfortable that you understand the significance of your different options, okay?
All right.
So what I'd like to understand first from Ms. Convery or Mr. Abate is what the state's offer is to Mr. Hinton, if there is a timeline for that offer, and then thirdly, what Mr. Hinton's exposure is if trial didn't go well for Mr. Hinton, meaning, Mr. Hinton, if you were found guilty of the charges in the indictment. And I'm focused on everything except the jail incident because of my ruling. What would be tried the first time through would be the incidents that I have deemed are sufficiently connected because of geography, time, and the nature of the allegations. They'd go together, but the alleged aggravated assault at the jail would be for another day, if it was even necessary after the first trial. No problem.
Good morning, Judge.
Good morning.
Just to, I think your first question was what the state's plea offer was. It was a global offer for all the charges in the indictment, so counts 1 through 17 for 30 years to serve. He'd be pleading to every count in the indictment, and his maximum exposure, based on my calculations for counts 1 through 14, which are the counts that will be tried if the case was to go to trial, is life without the possibility of parole plus 181 years. For the remaining counts, 15, 16, and 17 for the jail stabbing, that would be an additional 30 years if that case was pled to or gone to trial, or there was a trial subsequent to the first. The plea offer, I was just talking to Ms. Convery, and I know defense counsel had asked how long it would be kept open if the case was continued to the next calendar. I think I'm keeping it open for till maybe next Tuesday, based on the fact that the state's going to continue to get ready for trial, and it doesn't need to be an exercise that leads to nothing on the day of trial to take a plea. So we would leave it open until next Tuesday, so we could have the weekend to speak with his family, his mother, his father, and other members of his family.
Thank you. That answered all my questions. It made me think of one more, however. The murder that is alleged in the indictment occurred on May 31, 2016. How old were you in May of 2016, Mr. Hinton? Pardon me?
17 years old.
17, okay. Ms. Young, anything you disagree with that you just heard from Mr. Abate, other than is the offer being kept open or not, but what you understood the offer to have been and Mr. Hinton's potential exposure if he were to go to trial and to be found guilty.
Your Honor, I agree that that is the plea offer. Some of the counts I believe would merge. I believe count 3 was one of the counts that was severed, along with 15 through 17. And I came up with life without plus 245 plus a consecutive 15 for the gun and knife charges plus 12 months for the misdemeanor as to everything. So I think we're pretty close, and that it's about life without plus 260 as to the global. The plea was to 30 to serve, which is below the minimum mandatory.
Sure. And Mr. Hinton is not a recidivist in any shape. So the 30 years would be 30 years up to pardons and parole, whether there is any eligibility there.
He's not a recidivist, Your Honor. However, my reading of the statute, if the court was to give him life based on all the evidence that the court heard at trial, if he was to be found guilty as to counts 4, 5, or 6, the murder and the felony murder, and the court imposed life without, he's not parole eligible.
No. I didn't ask the question. Well, I agree with that. Given Mr. Hinton's age at the time of the alleged murder, he is eligible for life without parole. If he got that sentence, he would die in prison.
Yes, sir.
And we'll talk about that in a minute. My question was, if Mr. Hinton accepts the offer, and I agree that that's a reasonable sentence, and impose a 30-year term, he's not a recidivist, so that wouldn't be 30 years to the door necessarily. Is that your understanding?
I think it would be, Judge, minus the time that he's actually served, which is almost 1,900 days.
Okay.
I think that it's because it's one of the enumerated violent felonies that it takes him outside of the good time, gain time.
Okay.
And that it would be, I think, 24.8 years.
So it would be like a an armed robbery conviction.
So,
You're
no, it's a
okay.
departure.
Okay.
Below the minimum, yes, sir.
Yep. Understood. All right. Thank you. So, Mr. Hinton, I'm hearing the state offering you the possibility of entering a plea to all the charges, and in exchange for that, not needing to bring in surviving victims, et cetera, they would recommend to me that I sentence you to 30 years. In any of the scenarios we're talking about, you obviously get credit for all the time you've been in, and you have been in for an incredibly long time, which is why I'm anxious to get closure on your case, whether that means trial, get some jurors in here, or it's a plea. But what I'm understanding is that the state would recommend 30 years to serve, and getting some weird feedback. Thank you. I don't know what caused that. And that would resolve all the charges. Do you understand that to be the state's offer?
Yes, sir.
Okay. You understand that if you go to trial and you're found guilty, and no one's assuming that, obviously if you're found not guilty, you're free to go. Well, you'd have to deal with the second part of your case, the aggravated assault at the jail. But if you're found not guilty, there's no sentence. But if you are found guilty, then you could be looking at a sentence of life for the murder, potentially life without parole, and then a whole bunch of years after that. And frankly, whether it's 181 or 245 is a big number, and it's after a life sentence. And if you were sentenced to life without parole on the murder or the felony murder charge, those additional years really would never come into play anyway, because the life without parole would mean what it would say. And how many more years you hope to be alive, they'd be years that you are in the custody of the Department of Corrections. So I need to make sure you understand the outer limits of how bad things could be if trial didn't go well. Do you feel like you understand that?
Yes, sir.
Okay. At this point, Mr. Hinton, are you interested in pursuing a plea along the lines of what Mr. Abate described, or are you interested in going to trial?
Going to trial.
Okay. And have you had a chance to talk about the decision of plea versus trial with Ms. Young, your attorney?
Yes, sir.
And have you had a chance to talk with any family members about that?
Yes, sir.
Okay. And based on those conversations, your decision is to say no thank you to the state's plea offer of 30 years and instead go to trial and see what happens.
Yes, sir.
All right. Do you understand that if you change your mind after we get a jury in here or we're talking about getting ready for trial and say, wait a minute, I want to work things out, you cannot require the state to renew that 30 years to serve.
Yes, sir.
Then they say, well, now it's 40 because we had to do X or Y or Z and Mr. Bernstein's family had to look at pictures of what happened or whatever the situation is. The state are not required to renew this offer or extend it beyond next Tuesday. Yes?
Yes, sir.
Okay. Well, I find that Mr. Hinton understands the offer that has been extended from the state, understands what could happen at the outer ranges if trial did not go well for Mr. Hinton and a jury found him guilty of what he's charged with in the indictment. And at this point, he is electing to move forward with the trial, which is his absolute right. And we need to figure out when we're going to do that trial. Mr. Hinton, Ms. Young shared with me that some members of your family have talked with her about bringing in a different lawyer. Do you know anything about that?
I spoke with them yesterday about it.
Okay, tell me what you think the plan is. And I'm asking because we will try this case soon. We may try it starting on Tuesday. If we don't start on Tuesday, it'll be soon after that. And that's complicated for a new lawyer coming in. But I'm not going to let that new lawyer say, I need 6 months. I don't know, Mr. Hinton. The case file is this thick. I have to read all through that. The lawyer will need to, as they say, hit the ground running and be ready to go so that if trial is on Tuesday, he or she says, great, let's pick a jury. If trial is in September, he or she says, that's going to be a whole lot of work, but I will be ready. Put differently, bringing in a new lawyer is not going to be a sufficient basis for me to say, I'm going to give everyone more time. Do you understand that?
Yes, sir.
Okay. And you and your family need to make sure that you explain that to any potential candidate, either to assist Ms. Young or to replace Ms. Young, that that lawyer is going to be expected to be trial ready when we call this case for trial, either Tuesday or at some point in September. Understood?
Yes, sir.
Okay. Mr. Abate and Ms. Convery, tell me your thoughts about when we should try the case. It's on a calendar for next week. We have a jury, a panel of 60 coming in on Tuesday the 31st. We call the calendar on Monday the 30th. And I'm going to hear from Ms. Young in a minute because I know she's raised some concerns and has asked for some more time. Ms. Convery, you were just in a 8-day trial, whatever it is, and here's another trial right around the corner. Ultimately, I'm going to weigh most heavily Mr. Hinton's choice because he's the one who's been in jail for almost 1,900 days, but I want to factor in everyone's perspective on this.
And good morning officially to the court. I haven't even told you that yet. I am here with Mr. Abate because for a couple of reasons. One, because I didn't know how long my jury would be out. So that we could be ready for the court, I went ahead and got wheels in motion so that we were prepared should Your Honor call this case on Tuesday. And two, because I may require, unfortunately, some oral surgery as early as the end of this week for a wisdom tooth issue. And so we'll be ready when the court calls us with some combination of representatives from the state. Obviously, this court knows and Mr. Abate, and my opinion about Mr. Abate is that he's capable absolutely of trying and being ready for anything that I would be trying. So it will be a representative most likely from the gang unit, probably Mr. Demetrius Smith and Mr. Abate or myself, because maybe the surgeon says today I can get out of this surgery, but regardless, we'll be ready. Just for what it's worth, of course, I probably personally prefer the end of September or that calendar. But as always, we will be ready when reached, when we're called. I understand the court's concern about the age of this case. I also understand that some other positions on the calendar are resolved, and that's just where we fall right now. I also know that Mr. Hinton has been in custody for an extremely long period of time. We have family members interested in a resolution of this case and several witnesses with the same interest. So ultimately, of course, we'll be prepared when the court calls us, but wanted to let you know while there were some new representatives here today.
Okay, but you don't object to bumping things to whenever. The next calendar we have is actually going to cover 3 jury selection days. We've got this cycle where about every 2 weeks, I'll have the opportunity to pick a jury. But rather than come up with a mini calendar in front of each of those, there's going to be a bigger calendar that we will publish hopefully tomorrow. And so the question is whether Mr. Hinton goes on that calendar. Well, we start on Tuesday. And if he goes on that calendar, then there'll be 3 days from which we could pick. One of them is kind of spoken for because we specially set a case that Ms. Hall will be handling for the state and Mr. Webb, Charles Webb will be handling. So there'd be 2 other dates we could work with that wouldn't be this Tuesday.
Right. Understood. No, I don't have any objection to counsel's request. We spoke at length about it. The first day I got called out, I called her immediately and said, what? So no, I don't have any objection. But again, we'll be ready when the court deems it's appropriate. I think I may end up having a couple things on your Honor's September calendar, and I'll be prepared for that as well if you decide to reset Hinton at least momentarily for the September calendar.
Okay. And your current estimate for how long the state's presentation would take, assuming we don't have the technical issues that you experienced last week?
I think we can do it it would take us the full week. And so for the Tuesday selection, I will spill over into the next week almost certainly.
Okay.
I think I'm probably a little bit longer than Mr. Abadi just traditionally, but I think regardless, because of the number of witnesses and the number of incidents that are on the indictment, we will spill over into that next week just for the purposes of if we started on like a Monday and we're a Monday selection, I think we could be rested on the Friday. With closings and deliberations, we're probably always a spillover case, but
Okay.
I don't think it's so complicated that it's for sure a 2-week situation or anything like that.
Got it. Thank you. Ms. Young, if you would please put on the record whatever you want to add to what you've already put in the record through your filings in terms of a request for continuance.
Your Honor, I would stand in my place. I think both motions, in addition to what I was able to put on record already today, would respectfully create the ability to ask in good faith for the continuance, not for delay purposes. And I agree with what Ms. Cambria said in terms of time. I think we start on a Monday. I tend to try cases pretty quickly, unlike speaking to the court. And I expect we would be finished with the 4 counts that are redacted by Friday and be able to close deliberations either sometime Friday or Monday morning.
Okay.
Thank you, Judge.
Mr. Hinton, I don't want you to share with me the contents of your conversations with Ms. Young, but I do want to make sure that you and she have talked about a continuance. Because as I said at the outset of this conversation about scheduling, what I'm most worried about, I'm very concerned about the number of victims in this case, family members of victims, and they're seeking closure. You're the one, though, who's been sitting at Rice Street for 1,900 days. The type of continuance we're talking about is weeks and not months if we don't go forward on Tuesday. But I want to hear your perspective on whether you're comfortable with that or not. I understand we'll call it the strategic reasons that Ms. Young has put forth, not meaning it's a game, but there are things she'd like to take care of based on things you've told her. She has some legal concerns about an order that I entered. I don't want to burst anyone's bubble, but I suspect I won't be certifying anything for appeal. Based on the rulings I made, those would be something that could be addressed in a motion for new trial, if there needs to be a motion for new trial, and then ultimately an appeal. But Mr. Hinton, I want to just get your pulse on whether you are comfortable giving Ms. Young a little more time to do the things you and she have been talking about or to give your family more time if you and they decide you're going to bring in another lawyer, to get that lawyer on board, and then that lawyer has more than until Tuesday to be ready.
Yes, sir.
You're okay with the continuance?
Yes, sir.
Okay. All right. Well, that is helpful to know. Trying to think if there was anything else we needed to cover. Ms. Convery or Mr. Abate, anything from the state? Mr. Abate is still drinking from the hot fire hose right now. I'm not quite sure.
No, I don't think so, not on this case. Just on behalf of the state, I was going to inquire as to, I know I've got some DAs waiting in the wings on probably the decision from the court on which case is next, because I know for Mr. Tavares, I just wanted to get an opinion from the court if that was next up, so we could just make sure we're ready for whatever the court.
Sure. So what will happen on Monday when we call the calendar? Before Monday, I'll let you all know what we're doing with Hinton. Is it going on Tuesday or is it being continued? If it's continued, you don't need to be here on Monday unless, because we'll produce Mr. Hinton just in case. If you learn, Ms. Young, over the course of the weekend, change of heart, this case is going to work out, we can take the plea on Monday. Monday is going to be resolving a few cases. There are a handful of cases on the trial calendar that I've been told will be pleas on Monday. And so we'll take those. All that is left that is triable, a whole bunch of cases got knocked out because we have a new conflict defender. And he, poor guy, needs to meet his 37 clients. So he is climbing a very, very steep mountain right now. All that is left is Mr. Hinton's case and Mr. Tavares's case, which was a special add-on from the calendar that didn't happen this week. So we will either be trying Mr. Hinton or Mr. Tavares now that Mr. Williams, the gentleman who just appeared, has pled out. That was the other remaining case. But I think Mr. Parrish is aware of that, and he and I will talk in a minute about some of those logistics. I just need to talk with Ms. Nelson offline, and then she'll get an email out to both sides. If I'm granting continuance, I'll enter an order. It's important with a case this age that that's all documented, and I'll provide the reasons why. And I'll memorialize my exchange with Mr. Hinton in that order. So I will let you know that, but Monday will be the call of the calendar. If Hinton is continued and the lawyers don't sort something out over the weekend, then Ms. Young, you don't need to be here. But as a fail-safe, like I said, we're bringing Mr. Hinton over should something sort out over the weekend.
And I'll be happy to be here if the court wishes as well.
Okay. Ms. Young, are there other things we need to talk about in connection with Mr. Hinton's case? I'm not aware of anything I need to rule on. You wanted some time to digest the order and maybe file something, and you're free to do that, but I've given a preview of how that might play out.
Yes, Your Honor. Thank you for the court's guidance. There's nothing else from the defense.
Okay. Mr. Hinton, do you have any questions for me about what's going on?
No, sir.
Okay. Well, I think that's where we're going to leave it. Ms. Nelson will be in touch with Ms. Young, Ms. Convery, and Mr. Abate this morning with what we're going to do. We just need to huddle up. And Mr. Parrish, you'll get looped in, and Mr. Tavares will get looped in. So you can plan your weekend accordingly, which doesn't start for another day and a half anyway. So, all right. Thank you, everyone. Yes, ma'am.
Well, Judge, I'm gonna go keep drinking. Get your email.
All right, go do that.
You didn't want me on Friday.
All right, you too. Hey, how are you?
Is Deidre here today?
She is not, but we can connect you. Well, she may, hold on.
Yes, I'm still here, Judge. I didn't want you to kick me out.
I didn't kick anyone out.
No, I was just saying, I didn't want you to kick me off.
Nope. You need to talk to her? Sure. Look,
Hey,
I can't make it move anymore.
Can you see me? Okay, let me see. No, I don't see you.
There it is.
Hello, how are you? Her issue resolved with the CPO? I don't know.
Is
And the
this
reason why I don't-
Leon Adams and Isaiah Adams?
I think so. The one you emailed about, I think Stephanie said you did submit the order to the CPO address.
Yeah, so Michelle's handling that for us because it's a motion for new trial. And she told me all about how DOC is not included in that distribution list. I don't know if it's fixed, but Michelle would know that, not Deidre. She's on it today.
I'll email her.
Okay,
Okay, I'm just
Following
trying
up.
to make sure everything
Great.
is taken care of.
okay, I appreciate that.
And you probably are seeing me copied on the email because I actually was the one that reached out to English because we had previously talked about that.
Yeah.
And so you probably saw that stream of emails, but I
He
did
forwarded it all to me, and I'm just
Okay.
trying to make sure that you got it taken care of, or if you need us
Okay.
additional to help you.
Okay, I'll double check with Michelle as well.
Okay, thank you, Deidre.
You're welcome.
Thank you, Judge.
Thank you for checking up.
No problem. Got to make sure you're okay.
Yeah, I appreciate that. Got to keep those motions for new trial moving. All right. So I'm gonna go back in chambers and I'll give you a call, Deidre, if that's okay.
Oh, okay. I thought you were talking to Paris, so I did.
He left. I was gonna talk to him more, but he took off. So that's fine. We'll reach out to him later. Anyway, I'll give you a call in a little bit. Thanks, Karen.
Okay, Judge, you sure you don't need me to come in?
I'll be strong. I'll get by.